Good afternoon and welcome. We are so excited to have a rock star panel here with us this afternoon talk, to talk with us about their firsthand experiences in navigating legal considerations and creating and implementing the youth diversion programs in Los Angeles County. And so, super excited to have Leah Zeidler Ordaz from the UCLA School of Law Criminal Justice Program, Taylor Schooley from the Los Angeles County Department of Youth Development, and Ali Hazard from the Healing Arms California Conference of Equality and Justice. Um, really looking forward to this conversation and learning with this, as I said before, rockstar panel. And with that, I welcome you all here. Um, Glad to have you here with us. And I will turn it over to Leah.
Thanks so much, Jakira, and good afternoon, everybody. I am Leah Zeidler-Dawes. I use she, her pronouns, and I do youth justice policy work with UCLA School of Law's Criminal Justice Program. And as our wonderful producer kind of announced at the beginning, as you all are coming into this space, and I welcome you to here today, if you could just put into the chat how you would describe your role with justice involved youth, so then we could get a good sense of folks who are in the room. And just taking a look at what I'm seeing in the chat already, I'm seeing a lot of folks who are working like across the country, so it's really exciting to see that we have such a huge swath of folks nationally. And then additionally, I'm seeing a lot of juvenile court employees, probation staff, folks that are working for community organizations that are doing juvenile diversion work, and some public defenders and state employees. So thank you so much, and welcome to all of you. We actually have a couple of poll questions just to get, again, a better sense of who's in the audience. So if you could just answer this first question, which is, does your county have a diversion program for you? And so we'll take a few seconds for folks to vote, and then we'll see what the results are. And it looks like this is really great to see that most of the folks that are here today, you already have existing diversion programs, 88%. There are 3% of folks in here that don't have a diversion program in their local community or county. And there's some folks here that don't know, which is totally fine. And we'll get more into specifically what LA County's diversion program looks like and how it works in a few minutes. But we have one more poll question for you. And that is, have you ever, or I'm sorry, does your jurisdiction have laws on record sealing for youth and diversion programs? And it's okay if you don't know too, because that's what, the whole point of this presentation is going to be about, is the necessity of, having legal service providers involved in your work to kind of provide that support and provide that information in collaboration with providers. Yeah. So, I mean, looking at these poll results, it's a significant percentage, almost 50% of folks who don't know the answer to this question. And so, again, it'll be really interesting to kind of unpack the ways in which legal services can support your diversion programs and, how we've done this in LA County in this presentation. And so what I'll do now is I will pass it over to Taylor Schooley, who is with LA County's Department of Youth Development, and who's going to talk a little bit about LA County's pre-arrest and pre-booking diversion model.
Thank you so much, Leah, and hi, everybody. It's so good to be here, and it's so wonderful to see all of your roles and all the experience you're bringing. I'm going to pull up my slides really quickly and then jump right into it before turning it over to my other colleagues. as Leah said, my name is Taylor Schooley. I am with the Los Angeles County Department of Youth Development. And I have been collaborating with the incredible community of youth leaders and county partners and community partners who have made LA County's youth diversion and youth development work possible in the last decade or so. Some of you I see on this call and many, many others. So my part of the presentation is really just to give you all some context for what the youth diversion landscape looks like in Los Angeles County and how we got there, just so you can better understand how we'll talk about the real focus of this conversation, which is the role of legal support in that kind of model and in equitably and effectively reducing justice system involvement for young people in our county and in any jurisdiction. So this slide is just a little bit of a timeline, a little bit of history for that context. You'll see that really in 2017 in our county, decades of youth and community organizing led to a moment where the county established a collaborative planning committee that was tasked with co-designing a plan and a model for equitably reducing youth arrest in Los Angeles County. And that process, which was really a collaborative process that took place over the course of about a year, led to the design and the launch of a really data-informed and regional program model, meaning that we took really seriously the regional needs of our county, and we took really seriously the task of looking at our own data to understand what we could learn from other jurisdictions who had done really amazing work in youth diversion, what didn't actually feel like the right fit for our county, and how we could pull in what worked and lessons learned from other jurisdictions as we were building something that was flexible enough to support the scale and the unique needs of Los Angeles County and the over 80 unique communities and cities in our county. And it also led to the establishment of an office, a central coordinating office that was housed in the county. At the time, it was housed in the health agency in Los Angeles that was in charge of supporting that program model and expanding that program model over time. Then you'll see over the last few years, that work has really been built upon. So, the work began with central county coordination and funding that I'll talk more about in a second. And then in 2019, we were asked to build on the sort of successes and the lessons learned of our own work in Los Angeles County. And that led us to another collaborative design process, and a moment in 2022, just last year, where the county established a new department, standalone county department of youth development that was really taking the torch from that original smaller coordinating office. And this is just a little bit of additional context on why we created the model that we did, and a note that if folks are more interested in this kind of process and history, we were lucky enough to collaborate with the Annie and Casey Foundation to put together a collaborative creative chronicle of our process and our history of designing the youth diversion model in LA County, and the link is here if anyone wants to read more. This goes into detail about things like how did we determine who would be eligible, how did we determine our funding structure, and our structure for capacity building and shared learning. But for today, I'll just talk a little bit more about how the youth diversion and development model works in Los Angeles County, and talk about it first from this perspective of how it works in terms of how it's coordinated, what sort of shape of coordination looks like, in case that's helpful for folks, both to understand how we talk about the role of legal support a little bit later on, but also for anybody who's thinking about how this relates to your own work in your own jurisdiction. So first, the central coordinating agency of the county, so originally the Division of Youth Diversion and Development in the Department of Health Services, and now the Department of Youth Development, provides funding, coordination, and oversight to a community-based network of youth diversion providers. And we have a really mutual relationship, or strive to have a mutual relationship with those providers, where we learn from one another, we come together regularly to troubleshoot together, and to improve the model as a network, as a collective. 2, local law enforcement agencies, including the DA's office and the probation department, have partnerships with our office, our department, and with their local community-based organizations that allow them to refer young people to the appropriate organization based on where they're located regionally, or for the DA's office and the probation department based on where the young person lives, that is eligible for referral. And that referral partnership is really the structure of our model, the sort of skeleton or scaffolding of our model here in Los Angeles County, that allows us to think about both flexibility, so that a young person who lives in one part of our county with really unique regional or geographic needs can have their own experience that's tailored to them, and a young person who lives on the other side of our county, where there are a whole other set of regional or geographic needs, can have an experience that's tailored to them. Next, community-based providers who are on the ground, building support systems and a menu of services for young people that is based in the principle of youth development and the sort of holistic understanding of the range of activities and services that any young person needs to thrive. Receive coordination, technical assistance, program management from the county, and work to make changes to the model, as I mentioned, for improvement. And then lastly, that network of community-based service providers are able to connect with one another and grow over time. This is how that model works as a young person experiences it. I won't go over this for the sake of time, but just so that you can see it here, how that structure plays out for a young person in our county. And I imagine you'll have these slides to review afterwards, all the way through accessing their own individualized care plan and care coordination through being able to successfully complete and hopefully join our network of partners and youth leaders as we continue to engage in youth leadership development over time. And then I'll just end my presentation by starting to set up what both Leah and Ali will talk more about, which is why is it important, based on our experience, to have integrated legal support as we think about this model. And I'll start by saying that we were really lucky because of the process that I just went over, because we really engaged young people as equal partners in designing our model from the beginning, but also throughout. It's never too late to do so. And because we did the same with community-based providers and community partners, we were able to identify a need that the county hadn't originally anticipated pretty early on, this need for a real sort of flexible and responsive legal support for young people, for families, and for community-based providers pretty early in the life cycle of our work. And what that meant is that we were lucky enough to be able to have a heads up earlier than later to work with our partners at the University of California, Los Angeles School of Law's Criminal Justice Program to develop a proposal for a role, really a sort of set of capacities that would fill what we anticipated to be a key gap in the initial program model, until we could build additional infrastructure, but also so that we could learn a bit more about what exactly would be needed when we were in a place where we really imagined there was going to be a need for legal support for young people, for families, and for community-based organizations in this network, but that need would likely be evolving over time, and that we wanted to have somebody who could help troubleshoot and identify needs as things grew and as we learned more about what the actual pain points or opportunities would be. So we didn't want to assume or sort of apply a cookie cutter approach that wouldn't be flexible enough to adapt over time. And we're lucky enough to be able to make that happen and to have a youth justice fellow who could serve in that capacity in the first few years of implementing our model. And then just to close out my section, I'll say that this role, which is really a role of troubleshooting and connecting both young people, families, and providers to information about legal issues or questions, and to resources for legal issues and questions, has been invaluable for us, and really important for the providers in our network, but also for the young people and families that we all serve. And a few examples of the ways in which that's been really important for us that you'll hear more about in a moment, is when, for example, we experience in our network referrals that we think are contributing to net widening, or that are for young people who we think really should never have been arrested or cited in the first place, or when we experienced a policy change in our jurisdiction that meant we had a huge influx of young people who were part of a previously operating diversion program, in our case, the probation department citation diversion program, who were now coming into our network, or when additional support is needed to make sure that record sealing is occurring the way that it should. And in these last two bullet points, when there are just new needs coming up for young people, for families, or for the network, to help identify those needs and troubleshoot and be a thought partner and help solve them. So I'll stop sharing my screen now, after maybe just saying, if you have any other questions, please feel free to reach out and let me know. And I'll turn it back to Leah.
Thanks so much, Taylor. All right, so I will share my screen. So in this section, I am going to talk to you a little bit more about specifically about the legal services that I provided, how I kind of stepped into this role at the inception of YDD's diversion program, and just speak generally about the relationship in a little more detail of legal services to the work of diversion providers. And I'll introduce you a little bit to the toolkit that I wrote that's kind of the subject of this webinar. So getting into the relationship of legal services to diversion work, it's important to know that legal issues can arise at all stages of the diversion process. So from the stage of when folks are collaborating to envision something new, like what we did here in LA County, but even through the implementation process and beyond. And so the toolkit that I wrote kind of describes these issues in more detail. And I'll actually get into a few more specifics about what those legal issues look like, what some examples are on the next slide. And I think it's important to know that not only is the legal services work that I do linked directly to providing support to YDD or the Department of Youth Development, as Taylor noted. It was also put into place for me to provide support to the community-based organizations that were providing diversion services to young people and their families in the community. And I think, Ali will talk a little bit more about what that looks like. And additionally, to families and youth who are going through diversion programs. So it was kind of like a three-tier process. And of course, like with these legal issues and these different folks who are coming to me for legal services, there's different legal and policy questions that are going to arise depending on who the person is and what the issue is. And it's important to also note that, I anticipated, and again, this is my experience, I haven't worked in a county that has an already implemented diversion program that needs legal services, but certainly with a newly created program like DYD's, we saw a lot of questions around implementation. And so I did want to kind of stop and talk a little bit about what some of those issues are. And those are also going to be detailed more in the toolkit. But, as Taylor noted, one of the things that I worked closely with DYD on was mitigating net widening. So really, from a legal perspective, I was looking at questions around what types of charges in California are legally eligible for diversion. So I had to look at a lot of state law, local policy, but I also want to acknowledge that, you know, one interesting aspect of this question is also the building relationships aspect, which I think was, you know, something that DYD had to consider really closely, which is like if law enforcement agencies are making these referrals to diversion providers, you know, they might not necessarily want to refer every single case that's legally eligible for diversion. And there's some like give and take in the process of negotiating, you know, what ends up, you know, being the agreement between this county agency, the community-based organizations, and the referring law enforcement agencies around, you know, like what the diversion process is going to look like and what factors are going to be taken in to mitigate net widening. And so that kind of leads me into a second like legal issue that we looked really closely at all different points in time since I've been working with DYD, which is also looking at memoranda of understanding, which are the formal legal partnerships between referring agencies and like in this case, DYD, the county agency that is administrating diversion, and then also the community-based organizations that are providing diversion programs. Like I did a lot of, you know, looking at the terms of the different MOUs between these agencies and advising community-based organizations on their application to particular relationships that they had with law enforcement agencies. So a lot of times, you know, like these MOUs are negotiated by higher level, like executive directors of community-based organizations, high level county staff, and, you know, like folks at law enforcement agencies. But, you know, the folks on the ground who are doing the work every day don't necessarily know what those terms are or how those terms apply to the work that they're doing day in and day out. So a lot of times, you know, I was working with those organizations to better understand like what the confines were of the work they were doing. But I want to emphasize, even though those are kind of like two examples of things that came up through implementation, that it's really important to have legal services at any stage of the diversion process. And so my next slide kind of gives a little bit of a example that's more from the implementation perspective, like what's going on once you've created a diversion program, it's running in your community, and now you're kind of like seeing issues as they come in, right? And so, you know, Taylor's already mentioned this, but record sealing was a huge like policy issue that I worked on with LA. Essentially, like several different law enforcement agencies refer cases for diversion. We have 47 different law enforcement agencies in the county of LA. Not all of them are contracted to work with DYD, but like, you know, many of them are. I would say at the time it was like 7 to 8 different law enforcement agencies. And they each had different referral procedures in terms of like, you know, how they go about making a referral to diversion. Like, so some agencies would like cite or book a youth before making the referral or create a police report. And so that meant that any youth that was being diverted to a community-based organization had some sort of juvenile police record that was going to need to be sealed if they successfully completed the diversion program. And until very recently, you know, the state of California, we didn't have any laws that spoke directly to what it looked like to seal a record of a young person who went through a diversion program. We have a lot of laws that tell us like what to do if a young person goes through the juvenile legal process, like goes to juvenile court, you know, does probation, etc. But nothing about like if we're front loading diversion. And so once this law was passed, we had to really think about here in LA, like what is it going to look like to inform law enforcement agencies of their new obligation to do this type of record sealing, to ensure that youth who had been diverted to DYD before this law was passed could have their records retroactively sealed, and what that looks like, right? And so what the criminal justice program helped to do in that case was we individually worked with young people who were referred to us by the community-based organizations to seal those records. And we also worked with DYD to create a record sealing protocol. And then really quickly, I'm going to talk about a civil demand letter case example. So this is like an example of a type of legal issue that we provided assistance on to specific young people who were going through diversion. So in this case, this is California has laws that allow large retailers to send civil demand letters to young people or adults who are caught like shoplifting or caught by loss prevention, trying to leave stores with merchandise. And so a lot of times, like, families will get these letters in the mail saying that they have to pay civil damages of some, large amount of money, $300 to $500, with that demand due within 10 days. And so a lot of families were coming to the community-based organizations asking, wait a minute, my kid's in diversion. What is this letter? What does it have to do with diversion? Do we have to pay? And so, this is an example of a legal issue that's closely related to the diversion, because the petty theft or the shoplifting charge was referred to a diversion provider, but it's not necessarily something like, if the young person successfully completes diversion, it doesn't resolve the civil legal issue that's here. And so in these cases, the criminal justice program was able to kind of step in and work one-on-one directly with youth and families and answer their questions, and then additionally provide training support to all the community-based organizations to let them know like what to do, what steps to take when these letters are sent to their young people. And additionally, we've looked a little more deeply at like what is some policy advocacy that we could do at the state level to try to change these laws for young people. And I think I really want to just jump to introducing the toolkit really quickly. So I'm going to go ahead and stop sharing this part of my screen. And I'm going to share the actual toolkit itself with you really quickly, because I just want to kind of walk folks through what we have included here. So starting on page 4, we've got the table of contents, but I really want to call attention to the fact that we have sections that discuss in more detail net widening, statute of limitations, and MOUs, which I kind of briefly went over. We also have some implementation considerations that I didn't talk about, like consent issues, confidentiality questions about whether or not a youth's information remains confidential in the course of their diversion program, questions around mandated reporting, and what happens if a young person is in a diversion program but picks up a second charge. Additionally, I will also just really quickly show you page 7, which also we have a nice little diagram of the YDD referral process. So you can take a look at that later on. Taylor explained it, but if you wanted a little more detail of what that looks like, it's going to be here in this toolkit. And then finally, I do want to point out that we have a whole section on special legal issues in restorative justice diversion programs. DYD does contract with 2 different community-based organizations that do restorative justice diversion, and there were some very interesting and novel legal issues that kind of came up in collaborating with these organizations. And so I'm going to kind of use this to pass it off to Ali, who is one of those restorative justice diversion providers in LA County, to talk a little bit more about his work.
Hey everyone, good afternoon. So my name is Ali. So full name Alejandro Hazard with CCEJ, so the California Conference for Equality and Justice. We are one of the restorative justice diversion providers in LA County. And I've been a part of this organization since 2016, and our diversion program has been active and running since 2013. So I will go ahead and share my slides so y'all can take a look at my presentation. Let's see. Okay, perfect. So yeah, so my organization is, again, CCEJ, so the California Conference for Equality and Justice. And my program is Healing Harms, which is our youth diversion, youth conflict resolution program. And specifically in working with DYD, we're one of the CBO providers in our restorative youth diversion. So, let's see. So a little bit about CCEJ, just to kind of get us started. So we were founded in 1963 to serve Southern California, and we now serve a national audience. So we were originally part of NCCJ, which is the National Conference of Christians and Jews that came out of World War II as a nonprofit. That became then the National Conference of Community and Justice. And then we became CCEJ, so the California Conference for Equality and Justice. Our organization, we use a head, hand, heart model in the work to impact knowledge, experiences, and actions. So head for young people to think critically in the work that they do here. Heart, so that we tap into our emotions and our relationships. You know, the best work that we do is grounded in relationships and understanding that dynamic. And hands model, we also practice and then try on our experiences. So getting for young people to know and practice restorative justice here in our program. So in 2022, this program diverted about 228 youth in restorative justice diversion programming through YDD and DYD, excuse me. And then in 2022, we also have an adult training department that does fee-for-service trainings, organizational conflicts. They also trained about almost 3,000 people across different sectors, nonprofits, community groups, schools, universities, companies. So I wanted to share a little bit about what CCEJ does. So like I said earlier and has been addressed, we are a restorative justice program, one of the restorative justice programs in Southern California. So everybody functions and operates a little bit differently, but for us at CCEJ, how do we talk about restorative justice? So RJ being, for us at CCEJ, it's a way of being and interacting with each other. Like, that is how this work happens. We are not siloed, we work together, and restorative justice doesn't begin when you sign on the dotted line or when you enroll in the program. It starts when you enter the door, when we talk to each other on the phone. So it's a way of being and interacting with each other and embodying restorative practices. It is needs-based, so including social and emotional needs. We want to work with a young person in their full healing. And so really like working through with what they need as part of a process. Also for people who've been harmed in a process. Centering relationships, like RJ is grounded in relationships. And it is that proximity with each other and how we work together that really helps ground what RJ is. Acknowledges power dynamics. So, you know, in conflict, there is always differences of power. Whether there's a school conflict, it involves a teacher, an administrator, power dynamics in the family and in the home. So acknowledging that and how do we work with that in an RJ process. Promoting personal and collective accountability. So what can I do to make it right? And then how do we together in a circle process operate together to talk about accountability together and working together to resolve a harm that's occurred. And then requiring the entire community to be invested. So RJ involves everyone in a process. So for a young person who's committed an offense or harm, involving their support people who they want to bring to help them through a process, whether that's family, siblings, coach, pastor. So how do we involve everybody who's involved in an incident of harm? So with that, then what are goals of an RJ process for us at CCEJ? You can see them on the screen, but helping make victims and other parties whole and help participants heal. So understanding that in a restorative justice process, in healing harms, there is an incident of harm and people have been hurt and impacted. So making sure that we are responding to that as best as we can. Encouraging youth to take accountability for their actions. So RJ and restorative justice is acknowledging that where can we look at our choices, understand the mistakes that we've made, and acknowledging that accountability. So giving people harmed victims a voice and listening to the harms incurred. So giving young people who've been harmed that ability to speak, to understand this is how I was impacted, this is how I was affected. So involving a youth's family and network of care to prevent reoffending. So again, involving everybody in that process. And then when a young person goes through our programming, making sure that we are bringing a person back into that community, right? And it's like, we don't want to ostracize or exclude someone from committing a harm. We know that we want to make sure that we bring folks back into this process. So with that, so restorative justice, the goals of the process. So then our approach here at CCEJ. So a couple just tenets for us. So it's victim oriented. So we want to make sure that we're centering that person harmed and their needs in the process. Does that involve coming face to face with the person who's harmed you? Is there other ways to be involved in the process? If you aren't comfortable in that moment, do we use a surrogate? Do we talk about other ways to be engaged as part of this reconciliation process? Pre-charge. So want to make sure that we're working with youth that have been referred from court or probation. So it is not want to reduce net whitening, as has been said. So if it is not going to be formally diverted, we want to make sure that we're working with young people and not contributing to that net whitening. Trauma informed. So making sure that young people are coming to this program and understanding that they're coming with complex needs, past experiences. So giving them choice to participate in this process, consenting to participate, coming to our program, listening to what the program will be like for them, and making them or giving them that choice to be involved. Confidential. So what happens here stays here. What is learned here leaves here. So making sure that confidentiality is practiced at CCEJ, and then shifting the strength-based approach. Like understanding that there is a mistake that has happened, but that is not defining. Like we are not the mistake that we are, but that we are what is that whole person, who is that young person that loves activities, sports, games, and then making sure that we're also working with a young person in understanding who they are and who they want to be. So in terms of diversion, so what that actually looks like in terms of a program. So you can see here on the screen a little bit at CCEJ how we define that. So eligibility to our program is, conflict has risen to a chargeable offense. We have other programming for informal referrals, but for restorative justice diversion, that there is a charge that has occurred. There's an identifiable victim or person harmed. So making sure that we are acknowledging that we receive referrals where that has happened. Age limitation, so 12 to 17 at the time of the offense. So working with young people there. Pre-charge again, and it's voluntary. That young person has a choice to participate in the programming. If they don't consent to participate in our programming, then we would refer that file back to the referral source. So for CCEJ, working with law enforcement, working with district attorney offices to accept referrals as part of this DYD network. Incidents less than a year, and I think that's really important for us, especially in terms of proximity of time. So when we're working with young people, that there is that, and I'll get into that a little bit later. And on the middle and right side, you can see what is eligible referrals for CCEJ and what is not eligible. You'll notice that a lot of them are also victim-oriented or have an identifiable victim. So you can see burglary and criminal threats. We also at CCJ accept sexual harm cases. So on the other side, curfew, loitering, and if we have other incidences, let me see. I see some questions, but I'll continue with my presentation. So, okay, so In terms of our referrals there, you see what is eligible. So then in terms of what our program actually looks like, so here at CCEJ, this is our what our case phases look like. So when a young person enters our program and is a part of the program, this is what we see. So we typically, as I said in the beginning, receive a referral from a law enforcement agency. We receive that referral, accept it, reach out to that youth and their family, and then schedule logistics, welcome them into the program. Phase 2 being intake and enrollment. So for them to see what the program is, getting to know us, building that initial relationship, filling out paperwork and the enrollment process. And then once the young person is enrolled and the family consents to participate, then we really kind of get into the meat of the program. And so for us, it is phase 3 and 4. So prep sessions with a young person in the process. So talking about really working through a restorative justice process, understanding what happened, what you were thinking at the time, what have you thought about since, how do we make this right, and who do we need to make it right to? So really walking through in weekly or bi-monthly sessions, understanding what happened and the impact of our actions, meeting with a facilitator like myself, and really talking about this incident of harm. While we're working with that young person in this process, we also reach out to the victim or the person harmed in the process. And so understanding how they want to engage, understanding their needs, and do they also consent to the program? So just to continue a little bit more, so just phase 4 and 5 of our process is then phase 4 is really that circle process and really talking about that restorative justice circle. So having everyone who is ready and prepared in this process to meet with each other, understand the impact of our actions and harm, and then make an agreement in this process about what do we need to move forward and move on. So after that, phase 4, then 5 and 6 is case management. So what agreements need to be addressed? What steps do I need to take as a young person? Is it fixing a windshield? Is it writing a letter of apology? So really kind of walking through case management and then closure. So that in a nutshell is our program. The last thing that I'll share is just kind of, again, grateful so much to be a part of this process and be a part of DYD, the network, and really a testament to the legal issues that we work with at CCEJ. And working with UCLA law has been incredibly important to the work that we do. There are some diversion issues, legal issues that we run up with at CCEJ. So first one is just confidentiality considerations for providers. So working in restorative justice, this is a deep process where we're working with young people at a difficult moment in their life and working with them to talk about what happened and that harm. And so we're asking young people to engage in an open and honest process with us and acknowledging that accountability. And it has kind of already been shared with confidentiality considerations that those are not fully protected yet in terms of an RJ process. There's no state law protecting confidentiality, but mediation processes. And so it's been shared with a civil demand or any kind of civil proceedings outside of that. Like that is a consideration that we work with. And to give an example, working with a young person a year ago where a young person admitted to the offenses that happened, and then really having the parents concerned that a person harmed who wanted to engage in the process could continue this and seek damages in the future. And so having and working with Leah to really work with that family, talk about their concerns and address that it was really important to the process when we worked with that young person at CCEJ. Another issue briefly is just I'll also share is timelines for RJ providers. A big thing for us is we have delays in referrals. And timeline is a big thing with restorative justice, and we understand that the justice system has a different timeline than ours. And restorative justice moves at the speed of trust and really kind of moves as best as we can when a young person is ready in that process. So we want to also address an incident of harm as soon as possible when it happens. So in the past in the RJ, we've seen delays in referrals, limiting how long a young person gets referred to us from when a time of an incident happens. So when that happens, we want to make sure that we are accepting referrals that are within that scope, and that the referral charges don't take as long as they need to. And then, memories fade with a young person. So it's really important for us to work with that young person as soon as possible. Another one is just, a longer referral gets to us at CCEJ and we reach out to that person harmed. If there's, a delay in referral, that can further impact a harmed party and a person who's been hurt in this process. So if I'm reaching out to a person 2 years later from an incident, that adds further harm to that person who might have already processed that incident. And then I am reopening or re-traumatizing that person harmed. I have cases like that where I've had to be on the phone with a person harmed. And to give an example of that, where that impact of me reaching out 2 years later and asking, why wasn't this taken care of sooner? Why am I hearing from you now? And that those timelines can be a delay in an RJ process where we're building trust and relationships. So moving along. So the last thing I'll share is just benefits of working with UCLA Law, working with Leah. So for our program and our youth and families. So as a program, just having access to ongoing attorney support, really important for us. Having somebody who is available and ready to work with us as a provider when issues come up, and having that ability to navigate complex issues and concerns, civil demands, civil proceedings. Very important to tap on Leah and UCLA when we need that. Resource support for families. So when we're working with a young person and offering that holistic care, legal services can be part of that. And having that ready has been super beneficial for us as a program and something that we can offer, and adds further service to that young person and their family. Because of that, then we as staff don't have to devote time to, we can stay devoted to our casework, working with that young person through a process of harm, versus spending that time to navigate and look up legal issues. And then just briefly, trainings. So understanding trainings on confidentiality, mediation protection codes. It's been really helpful to receive that as well. And then for our families, just access to legal expertise, like having that access to meet with somebody, to meet with an attorney, to meet with that program, really understand what is happening, and then for them to make an informed decision. Do I want to continue in this diversion process? Do I want to go through the rigor of a restorative justice process? Reduced cost and time to the parent and caregiver, saving so they don't have to seek an attorney. They can talk to somebody who's available, don't have to take off work, don't have to go seek, spend that time and resource and energy to find that. And then the last thing is just feeling supported in their time at CCEJ. As examples, I've heard from parents, and that it's been incredibly rewarding and grateful that we have this service and ability to refer families when needed. So thank you so much. I will stop there. I'll also drop in the chat just a young person who's worked in our program, so you can also see just what the experience has been from a responsible youth who went through our program, and I'll drop that in. So I will go ahead and transition back to Leah.
So I was gonna say, I think I passed it back to Jaquita because we're gonna move into Q&A. Is that right?
Thank you, Leah. And thank you, Ali and Taylor, for all three of your awesome presentations. So there are a couple of questions in the chat that we might want to get to first. And this one, I think, Leah, is for you. They just wanted to, well, Brian actually already shared it, the toolkit about sealing. So he's ahead of us. But there is a question about, do most diversion programs automatically seal cases when you successfully complete? And if so, are those cases then expunged automatically after a year? And I don't know, Leah, if you can talk more broadly and Taylor, what you all have learned, because I know you've looked to other places around the country as you were designing your programs in LA County?
Yeah, and so I can kind of start this off by saying, I think this question is a really good example of why legal services providers are needed to work with different diversion programs in different jurisdictions, because I can't necessarily answer this question with specificity because I'm not sure what state you're in, what county you're in, what local policies are, what formal or informal partnership and agreements that your particular diversion program has with diversion providers or with law enforcement agencies or other referral agencies. And in order to answer your question, that's where I would start, by looking at all of those different things and then conducting that research to kind of write out a memo and like be in touch with you to respond to that. But what I will say is it really, more generally, I think it's going to depend on the type of diversion program. So for example, like here in California, we have, specific laws pertaining to how and when records can be sealed when a youth goes through a pre-arrest or pre-booking diversion program. And those laws look very different when compared to other laws on diversion programs that are, let's say, like we have an informal diversion process that's handled by different county probation departments. And so that informal diversion has a different set of protocols for record sealing. And then there's also like more state laws that govern diversion programs, like, for example, deferred entry of judgment. That's what it's referred to here in California when a young person, goes through the adjudication process and then, is placed on probation. And if they follow the terms and conditions of probation, then they can come back and have their record they can have their record sealed and the case essentially dismissed. And so those record sealing procedures are also different. And so you would need like someone to research, every different type of program and process that's specific and pertaining to your particular program. And I don't know if there's anything you want to add, Taylor.
Yeah, maybe I'll just add to what Leah shared in case it's helpful in response to Tashina's question is just the sort of high level, I think, summary that feels really right to me of what Leah said is, in addition to all of that detail and, echoing the need for careful research about, a specific sort of context that takes into consideration all of the relevant details. I think in general,
I think Taylor froze on us. So I do just want to, I'm going to go ahead and move on. And if she pops in, she pops in. And I think this is for you, Leah. There's a question from Erica asking, how do you get attorneys to allow clients to participate prior to an adjudication? This might be actually for Ali and for Leah. And will they see their participation as an admission of guilt?
You want to speak to that one first, Ollie? Because I feel like it's an interesting question in the context of restorative justice.
Yeah, absolutely. So how do we get clients to allow clients to participate? So working with that attorney, like asking, do you want to meet with me privately to talk about first before I talk to your client, and really walk them through what this process looks like. For an attorney, like being as open, as honest as I can, and trying to really practice restorative justice, right? That like trust, building that relationship, and at the end of the day, not lie either. So like, working through this process, it's still the confidentiality is still unclear. And then, you need to work with your clients for them to make the best choice possible, and then understand, but we work with UID, we have county protection as a provider. So giving that attorney as much assurance as possible, and the acknowledgement that there's no guarantee either. And I think, giving as much information without giving that young person, their client, the attorney, as much information to make the best decision possible for them.
Yeah, and then to add on to that from like kind of an attorney standpoint, because this is a really layered question. at least in LA County, like DYD's program is like pre-arrest, pre-booking. So the case is not filed. And so therefore there's no public defender who's appointed to the use case before they're referred to diversion. So the, like, kind of going off of what Ali said, like the, you know, like whether or not they consent to the program is entirely placed in the hands of the young person and their family. And so some families are, you know, like excited to participate kind of after hearing that because of this, they're avoiding, you know, like going through the legal process and having to go to court. And then some families, you know, they want to talk about what the options are and they want to weigh, you know, whether or not it would be better for them to fight their case in court. And in those cases, you know, what we've done is we've encouraged like providers like Ali to refer those cases to me so then I can like kind of talk through with the family. But I think that, you know, this is a really interesting question when you're also talking about, and I'm glad Taylor you came back on because I was thinking I wanted to kind of pass this second part of the question off to you as to what DYD's practice is. But DYD has a program called Ready where we receive diversion referrals from district attorney's offices. And so in that case, like now we're sometimes dealing with situations in which the DA has seen the case and they're aware that it exists, and then they're referring the case to DYD. And there have been some times where public defenders have been involved in that process. And I know that public defenders in our county have expressed concerns around, you know, participating in that program and how that could, participating in DYD is essentially like an admission of guilt. But my understanding is, and this is why I think Taylor, maybe you should speak to this, is that DYD and the DA's office has special protocols around the fact that, like, in fact, a diversion referral from the DA's office, and if the youth accepts and participates in the diversion, it's not considered to be an admission of guilt and cannot be used against them.
Yeah, that's absolutely right. Hi, everybody. So sorry about that. That's absolutely right, Leah. And, you know, that it's part of the benefit, at least for us, of having a central coordinating entity in the county who can help advocate for our network of partners, because we're able to set countywide policy like that, like saying, as we negotiate partnerships with the DA's office or other partners, we set, we make partnership agreements. We, you know, enter into MOUs that are signed by both entities, and then we sort of garner and build political buy-in to make sure our policies can be as strong as possible. Exactly to Leah's point, to say really clearly in all of our written agreements, participation in diversion is not an admission of guilt, and things that are shared in the course of a young person's referral or participation in a diversion program cannot be used against them to limit future opportunities for leniency. So yeah, and in entering into and developing that language, we worked really closely, Leah, with you, but also with Alicia, because it predated you a little bit. So with our partners who are thinking about legal issues in diversion, but also with the defense agencies in our jurisdiction. We engaged with them around the language, we received feedback, we made edits based on what their concerns were, and tried to construct language that would address them as much as possible.
So I believe we're at time, and I think there's only maybe one question we didn't get to in the chat, but I feel like it was about kind of victims' rights, and I'm pretty sure all of the materials that Brian dropped in the chat, there were some materials from Ali, which may actually kind of speak to that question around victims' rights. So I just want to, on behalf of the Juvenile Justice Strategy Group here at the Annie A. Casey Foundation, thank you all for participating, Leah, Ali, and Taylor.